Good day, Mr. Hockey.
Good day, Chief Justice.
How are you, sir?
I'm very well, thanks, Chief Justice, and you?
I'm very well, thank you. You've been an attorney for about 30 years, am I right?
Yeah.
And you've had several acting stints as the High Court judge.
Yes. I've acted for 4 full terms, Chief Justice, and 1 half term.
Did the acting stint allow you to adapt properly to the High Court environment?
Yes, it did. Chief Justice, my first stint was long ago, in 2004. I thought at the time that I dealt with the stint very well. I wrote good judgments. I enjoyed it. But the one area that I thought I could improve at that particular point in time was to get more experience in commercial and corporate law. And I did go back, and I went from a small firm to a very big firm, one of the biggest in South Africa, in 2007, and I've been there for 13 years. And it was a wealth of experience that I picked up there. The small firm, one tends to reach a glass ceiling, and in a big firm, one deals with very, very complex matters. So that complexity and the experience in commercial and corporate law is something that I think, as a black lawyer, I can bring to the bench.
Has it ever been a struggle for you to produce a judgment within the recommended period?
Not at all, Judge, Chief Justice. I've got no judgments over 3 months. I've got my own personal time period of 2 months. Many of my judgments I produce well below that within that period. There are 2 judgments that I delivered just under 3 months, just under. But there were reasons for that. It is, and if you will allow me, I can demonstrate. The last term of last year, there was a period. In fact, the judgments that I listed as outstanding at the time when I completed my forms, if you look at when those matters were heard, you will see that the four of those judgments, no, three of those judgments, reserved judgments, I picked up over a period of 4 days. It was an extremely busy term. And I think there was a lot of catching up to do in terms of the backlog because of coronavirus. The week before I picked up those judgments, there was another 2 that I picked up, which I completed by the time that I completed my forms. So the 3 judgments that I did note in my application form were all delivered within the 3 months. The one I in fact delivered on the 21st of December, just the day before that. I delivered another judgment that I just picked up after I completed my form. In fact, I delivered 2 judgments during that period. And the other 2 I delivered in January, also before the 3 months. I worked hard during recess.
Okay. All right. Now, just as briefly as you can, did you ever get an opportunity to put your arbitration skills certificate and certificate of training as an accredited mediator to use? Just as briefly as you can.
Yes, I did. I presided over matters. I presided over very confidential matters, and I presided on a local government level where there's when executives gets charged in local government, they normally there's investigations. They appoint independent chairperson of the disciplinary hearings. So I've presided over that, and several others. And my mediation skills you use every day. I use it in court every day.
All right. No, thank you very much, Mr. Hockey. Colleagues, may I have names of those of us who have questions for Mr. Hockey?
Makwanisha,
Lucas,
Matonsela, Dodovu,
Tepe,
Was there somebody before Honorable Dodovu? Okay.
and Schlemmer, please.
Breitenbach, please, sir.
Maya.
Thank you. JP, over to you, sir.
Thank you very much, Chief Justice and fellow commissioners. May I also similarly disclose that I have known Mr. Hockey for a very long time. I first invited him to act in the Western Cape High Court. I think it was in the year 2004. I consider him to be a friend, and we have a lot of mutual friends. At this point in time, Chief Justice, I have no questions for this particular candidate. Thank you.
Thank you, Judge President. Premier?
thank you, Chief Justice. Good day, Mr. Hockey. Thank you very much for being here. My first question, as will be to everyone. First of all, as I've always said, I'm a very proud South African, and I am very proud of our Constitution. And of course, the Constitution giving us the separation of powers.
Yes.
And in that light, and in the time that our new democracy has been in place, are you happy that those separation of powers are working, that there doesn't seem to be a creep across from the political, the executive, and the judicial? Do you think that we are on track?
Yes, Premier. I think it works. I think the judiciary is there as a very important pillar in democracy to see that there is no crossovers. There always will be, but there are checks and balances, and the judiciary is there to make sure that there's no encroachment of the executive, and we all know of the cases. There are cases where the executive encroaches on the powers of the legislature, and vice versa, and the judiciary, of course. The judiciary especially must be as a bastion of the rule of law. Must make sure that the judiciary rather does not encroach onto executive functions and functions of the legislature. And yeah, so I think it works. I think we get tested all the time. We have been tested. And they will be tested in future. There will be people that make mistakes. But I think we've got systems in place to make sure that the three arms of government works.
And then, Chief Justice, if I can follow up on that question. So then, Mr. Hockey, are you happy with the makeup of this commission, which is now obviously in the judiciary space, but loaded with politicians? I'm one myself.
Yes.
Go ahead.
I think it is. I'm happy. Yes, I think it's important. It's extremely important to have lawyers there. In fact, of course, there must be lawyers. There must be people from the judiciary, because they know best what it requires to be there, and what skills and attributes one must have to be a judicial officer. But importantly, people that are public representatives, politicians, representing the public, need to have a say as to who is going to preside over the cases of the public. So yes, I'm fairly happy. I do think the lawyers play an important role, but politicians and civil society must have a say, no doubt about it.
Thank you very much, Chief Justice. I've got one more question, and that is in reading through your CVs and the documents, and looking at even, can I say, in your own statements that you say that you perhaps have limited experience in criminal matters.
That's actually not true. I cut my teeth in criminal law. In fact, Premier, practitioners of my generation is expected to have experience in criminal law, family law, MBAs. It's just so when I started practicing in the 90s, we didn't have opportunities often to join the big firms that does commercial law. So I started off with a firm that does a lot of human rights, did a lot of human rights work, and my principal ran the criminal department in that law firm. And for 2 years, I almost exclusively did criminal law. After completion of my articles, that partner left the firm to start his own practice. And a year after that, in fact, immediately, I was tasked to run that department. And I was made a partner just about a year and a half after that to run that firm. But I very soon told him that criminal law, of course, it's important. It's important for purpose of access to justice, and everybody's got the right to decent, proper legal representation. But it's not something that I wanted to have my whole career focused on. So I very soon started doing other work. With the advent of our constitutional democracy, and you'll see in my CV in 1994, when UCT offered a course on constitutional law, I jumped and I did that course.
Thank you very much. Thank you very much, Chief Justice.
Follow up, CJ.
Thank you, Honorable Premier. Is that your minister?
Yes.
Please go ahead.
Mr. Oak, do you consider the Constitution the supreme law of the country?
Absolutely.
So,
absolutely, Minister. Honorable.
In that case, do you think it will be fair for us to ignore the Constitution in relation to the composition of the JSE and respect it on other aspects?
No, I think we have to abide by the Constitution, right? I think that the Constitution it's there. We have to abide by, but besides the fact that the Constitution makes provision for the composition of the JSC. I personally, there may be very other good reasons why there should be changes, but personally, I believe that the Constitution prescribes the right composition.
Thank you. Thank you, CJ.
Thank you, Honorable Minister. Honorable Magwanisha.
Thank you, CJ. Good morning, Mr. Hockey.
Good morning, Commissioner.
Your CV demonstrates that you are a member of many progressive organizations. And it also demonstrates that from 1993 to date, you have been in a position of authority at the level of a partner in 2 firms. Now, how many blacks and women did you brief
How many blacks and women did?
Did you brief as an attorney? In which areas of law? And to what an extent can you, if you can give me 5, who you can say I have contributed to these people being silks?
To the individuals?
Yes.
Honorable Commissioner, I've actually got, and there are other people as well. In my previous firm, we briefed in the 90s. There were not many opportunities for counsel. There are more opportunities now, but it's still, briefing patterns is still skewed. So
Let me help you. Let me help you for the sake of time.
yes,
Can we focus on Weber Wenzel?
where?
Can we focus at your time at Weber Wenzel, where you are a partner?
So currently, yes, Commissioner. Currently, I brief. In fact, Weber Wenzel keeps a statistic of who we brief, and not just in terms of the number of briefs, but I think it's also important to take in consideration the value of those briefs. Because you can brief somebody to go to 3rd Division or the motion court and appear for half an hour, and charge a minimal amount, and then you tick that as a brief black counsel. So one must also look at the value of a brief and the complexity of the matter concerned. I'm very reluctant to name names, but I can assure you, and my record shows that probably about 60% of people that I brief is between 50 and 60% in terms of value are black. I don't want to go into name people without their permission. So please allow me not to name names, but I give you my assurance.
Fair enough.
That is the case.
Yes, fair enough. Can you say the areas of law where you
Yes.
brief them?
Yes. So the areas of law, my practice at my last firm is mostly commercial, and some administrative constitutional law. So those are the areas. Those are the areas that I became very fortunate that I have very big commercial clients, corporate clients, and I had matters that are extremely complex, and where one matter, for example, there's a quantum of over 1 billion rand as a capital amount, and that we have run up now to 2.53 billion rand. So those are the nature of the matters. And in that matter, we brief black counsel.
Thank you, CJ. Thank you, Mr. Woki.
Thank you, Commissioner.
Just in passing as a follow-up, were you in attendance of the gathering by Weber Wenzel senior executives that I was asked to come and address?
I was there.
Where I raised the issue of briefing patterns, and if you were, has there been improvement ever since I raised my concerns there?
Yes, I was there. I was there, Chief Justice. And in fact, there was an ongoing discussion, and I think you assisted very much with in that discussion, and that in fact that discussion culminated in the firm keeping records, and there's been a major improvement over the years. And as I say, I was one of those to say that you mustn't just tick boxes; you must actually keep records. And there is an improvement, and I believe it is still going to improve. I do think that I think people took at heart what you said, but there were many of us within the firm that, of course, have taken up that discussion before the time that you came to address us.
Chief Justice.
Honorable Lucas? Oh,
Thank
May I please
I couldn't make us. I apologize, Honorable Lucas. It looks like, is there a follow-up or an addition?
It's a follow-up, Chief Justice Madonsela. It's my question relates
Okay.
to the same subject matter, all around the same area that we have just made.
Okay, you may just as well, you are going to come after Honorable Lucas, so do that and ask whatever other question you're going to ask. Sorry, Honorable Lucas, you'll come after him, I'm sorry.
Don't forget me.
Thank you.
No, look, in fact, it's the only question that I had. Oh, no, just the two questions, yeah. The first one is in relation to the fact that you are an attorney with Weber Wenzel. And I just want to get the assurance in my mind that you have nothing to do with the letters written by Weber Wenzel to this commission, JSC, in which Weber Wenzel represents certain organizations making certain demands to the commission, which I think might be problematic for me. Am I correct that you have nothing to do with it?
Thank you very much for that question. It gives you an opportunity to clarify something else.
Yes.
I, in fact, resigned. I've put in my resignation in January last year, and I had very good and fruitful discussions with my senior partners and others because, sorry, I'm going to digress a bit because I think it's also important. I joined Weber Wenzel in 2007, and I told myself that that would be a period for me to get exposed to more commercial work and to make a contribution to the firm in terms of transformation, etc. And I said 5 years. I stayed for 13 years because I enjoyed it so much. I enjoyed being part of the leadership of the firm. I enjoyed making a positive contribution in terms of transformation within the firm. So to come back to your question, I'm not even aware of the content I said. I didn't know that Weber Wenzel wrote. So I'm not a partner at Weber Wenzel. I left to take on a new challenge, and that new challenge, in fact, I'm a very determined person, and I set goals for myself, and my goal is to make a contribution to the bench.
Well, thank you very much. I just needed that clarity in my mind. Secondly, which is the question that I wanted to ask, another question is that I see that you cited one of the cases in which you appeared, which is a case of significance.
Sorry, I can't hear so well.
The case of significance that you have cited, in which you appeared, is one that is of some familiarity amongst lawyers. The Richtersveld community case, which went all the way up to the Constitutional Court. I just want to find out, what role did you play in that matter?
Yes. Thanks, Commissioner. I came in after the matter was heard in the Land Claims Court. I got involved in the Supreme Court of Appeal and more intensely in the Constitutional Court and what happened thereafter. And the role was really, we've reached the stage after the judgment to facilitate a settlement. I acted for the mine. The mine wasn't really the principal party in the litigation. It was really between government and the community. But the mine, of course, Alex Co, a state-owned company, was obviously a interested party because it owned the land that was subject to the matter. So
you were acting for the landowners against the land claimants?
We were acting for the landowner in that sense, yes. But it was really a role that we had to clarify what is happening. We had to obviously assist the court in terms of how the land was being used. We were not involved in the historical dispossession. That argument we were not involved in at all. So it was more what the land is about and how, especially after the case was successfully argued in the Constitutional Court, we also had to, of course, be involved in the final settlement. We weren't involved in the original negotiations. That was done between the community and government, the state.
What was the final settlement?
Sorry, what was?
What was the final settlement?
The final settlement.
Yes.
The final settlement was that the land was transferred to the community. Alex Core retained the rights to mine on the sea, the mining rights in respect of the land. The sea mining rights was, of course, not subject to the case, subject to the claim. So Alex Core retained the right to mine in the sea. The community was granted the mining rights in respect of the land, and the settlement involved a pooling and sharing joint venture in terms whereof the sea mining and the land mining happens under one umbrella, a joint venture.
Thank you, Chief Justice.
Thank you, sir. Honorable Lucas.
Thank you, Chief Justice. In fact, my question will be the same one as the one that was now raised by Honorable Madonsela. But I just want to understand from Mr. Oki. Good morning.
Hello.
The Richtersveld claim, according to the settlement that was agreed upon, is one of the biggest claims that was settled in terms of land redistribution or restoration of land to the original owners. But what should be the role of any legal firm that is supposed to be representing claimants, just generally, and particularly with regards to the Richtersveld, the fact that after so many years, the communities of Richtersveld are still not getting the benefits of this settlement that has been there?
Of course, as a lawyer, you're not involved in that kind of intricacies, but of what is happening there. But I think if I can make a general statement, I think it is very sad, very sad. It perturbs me that not only in the Richtersveld, but for other claimants as well, when things just didn't work out. And people that have been deprived of land then win through the land claims process ownership of their land back, but they don't see benefits. I think it is really, really sad. And I think not just as lawyers, but I think the government needs to also step up and step in and step up, because there's a lot of support needed, a lot. Things have changed over the years, and the use of land has changed. We're in a very modern society where the methods of the way that people conduct agriculture is different, and we live in a competitive world. And I think it is the role of the Department of Rural Development and Land Affairs, and they do. I'm not saying that they don't, but I think not enough is being done to support those communities. And I think we must government. I don't want to speak for government, or I don't want to speak. I'm not a politician, but at least. The least that we can say is that there are a lot of lessons that can be learned.
So my second question is a follow-up to the very same issue. I've noticed in the list of cases that you have mentioned that in the Supreme Court of Appeal, you have actually appeared for the community of the Richtersveld. Before 2004, you have appeared for the mine, for Alexco as a company.
Yes.
So I just want that
No,
clarity.
I-
And was
I-
there not a conflict of interest?
No, I must apologize if there's a wrong impression there. I always acted for the state-owned company in that matter, not for the community. I must say I had very good relationship with some community leaders. There's a lot of problems there, of course, but through the litigation and I was involved, and I got along very well with them.
Oh, thank you, Chief Justice. Thank you, Mr. Hockey.
Thank you. Honorable Dodovu.
Thank you very much, Chief Justice. I can see that you have written a lot of judgments around local government
Yes.
where political parties are involved. In your view, is there a lacuna in terms of the legislation, generally speaking, on local government, given one, the challenges that are facing local government, the crisis, as well as the tensions that are within local government? Is there something that needs to be done in terms of the legislative framework?
Let me say, I'm not an expert. I'm not an expert on local government. I've done work in local government. I've written, in fact, just yesterday I handed down another judgment concerning local government issue and the provincial minister with the MEC's right to interfere in local government. I honestly can't say whether there are lacunas, whether there's always room for improvement. And I think we're still a very young democracy, and we must not let opportunities go by where we can learn from something that is not working. But maybe the expert can tell you there's this problem, there's that problem in terms of the legislational processes. But if a set of facts, if a case is put in front of me, I would be able to identify what the problems are. But right now, broadly speaking, I think I can't think of anything else.
Okay, no, it's okay. I understand that. I looked at the questionnaire that you filled, the JSC questionnaire that you filled. In page 9, I see a lot of discrepancies. Is that human errors or
which case is that?
I'm saying at page 9 where you furnished information about the positions that you held. Just go to your questionnaire, the JSC questionnaire.
Yes.
And I want you to answer me directly, because if not, I will have to follow up some questions.
Yes.
I see a lot of discrepancies here and misrepresentations.
Where is
I'm asking
that?
myself whether is that human errors or is a misrepresentation.
Can you just point me to
okay. If you want me to go there, you say you were a member of Azaso.
Yes.
Between 1992 and 1998. Yeah, that's what you say. And
That's a mistake.
That is why I'm asking whether
the 8. I saw that last night. In fact, the 8 should be 9.
Because what we say now in this commission will have profound implications for you.
Yes.
That is why I'm asking whether is that a mistake, because
it's an error.
Azaso ceased to exist in 1987. Is that a mistake?
Azaso became Sans.
I know. I'm saying it.
Yeah, so it is an error.
In 1987.
It is an error. I obviously just took it as one,
Yeah,
but
yes.
Azaso morphed into it. It was a name change, really.
Yes, and
Yes.
and you also say that you were a member of SAICO, the South African Youth Congress, between 1992 and 1997. Is that a mistake or what? Because
That is also what I mean. There is before SAICO was formed, there was obviously youth structures.
I'm not talking about that.
You're talking
I'm
about?
talking about the fact that you were a member of the Silverton Youth Movement,
Yes,
which was affiliated to SAICO.
yes, it became.
Yeah, that's what you say. That's what you have written.
Yes.
And my point is that SAICO ceased to exist in 1990.
Yes.
And in terms of the information provided here, you were a member of SAICO between 1992 and 1997.
No,
Is that correct?
I'm talking South African Youth Congress.
Yes.
Was formed in the 90s.
Yes.
In the 90s, I don't know when it ceased to exist.
It was formed in 1987. It ceased to exist in 1990. But in terms of the information you've provided, you say you were a member between 1992 and 1997. That is why I'm asking.
Yeah, it's a mistake. It's a
mistake.
I got my decades wrong.
Yes, because this will have profound implications for you.
Yeah, no, I apologize.
If it's a mistake, it is.
The
last
apologize.
one, the Athlon action.
Before you move on that one.
Okay.
Through you, CJ. Were you a member of SAICO?
Yes, some trouble, Malama.
Were you a member of SAICO?
I was a member through. I was obviously didn't serve on the executive.
Yeah, not that.
I was a member through a branch
of SAICO.
Of SAICO, yes.
When?
It was in the 80s.
Mm-hmm.
I can't recall when SAICO was formed, but obviously we had our youth organization before. We were part of the formation of SAICO. So it was in the 80s,
Okay.
Honorable Malema.
Okay, thank you.
Sorry, I apologize. That is embarrassing era. I got the decades wrong.
Actually, I must say, I'm very, very good to you. The last one, the Athlon Action
Committee, there's a mistake there as well.
Committee.
Yes.
Yes, for me, these are important historical moments in our country, and I'm jealous about them because I don't want mistakes in that respect. With that, thank you very much, Chief Justice.
Thank you so much, Commissioner.
Thank you, sir. Commissioner Tsepa.
Thank you, Chief Justice. Good day, Mr. Hockey.
Hello, Commissioner Chepe.
I just wanted to discuss something in the GCB comments.
Yes.
They say your judgments there appear to be a lack of constitutional matters, or that you don't seem to have had any constitutional. You didn't have an opportunity to engage on constitutional law matters. They do say that in your practice you have done some constitutional law matters. I just wanted us to clarify that issue, whether while acting you had an opportunity to engage with constitutional law principles.
Yes.
And if so, when, which judgment would those be? And if you could just take us through, and it's in the context of Section 39(2) that I'm asking this question, and I would like you to just take us through.
I think that the Bar Council was very complimentary, but they missed some of the judgments that I wrote, or they didn't really study it very carefully. With due respect, I think I've got a lot of support from them, but they missed the point. There were few, but if you want me to point out one, there's the issue of the it's called the plaaslike besorgde inwonersvereniging versus various political parties. In fact, not various political parties versus the George municipality, which concerned the election of the executive mayor, which happened last year during the early part of the lockdown. I think they missed the point that they had dealt with political rights, and what I said in the judgment, the judgment deals with a lot of issues that if you deny a public representative somebody that's been democratically elected by the public, if you deny that person a right to vote, then you make nonsense of the right in terms of Section 19 of the Constitution, of the right to vote. So I did deal with the constitutional issue in that matter. There are also other matters where I dealt with constitutional matters.
Okay, thank you, Mr. Hockey. The second question relates to other adjudicative functions that you would have engaged in other than the time when you were acting at the High Court. Do you have any, and what role do you think they play in were you to be appointed as a judge?
I don't quite understand functions in terms of?
Any other adjudicative functions that have you been involved in? Arbitration, quasi-judicial fora?
Yes.
Yes, and could you tell us a little bit more about them, and in what way do you think they will assist you in your role as a judge, were you to be appointed?
Yes. Yeah, thank you, Commissioner Chepe. I dealt with it a little bit early on, but I did mention that arbitration often by the very nature is confidential in nature, and I obviously can't divulge the parties and the nature of the disputes, but I were involved both as a litigant and as a presider in commercial arbitrations. I did mention also earlier on, I think I did mention that I also did one particular very sensitive matter on local government where I acted as chairperson. And when it comes to mediation, if you consider that also as a quasi-judicial function, all the time in my litigation, I think it is so beneficial to your clients if you have good mediation skills, because lawyers tend to be in the system that we have. Lawyers tend to only look at their clients' case and their and their argument and how they can build up their clients' case. And I think because of my skills, I look at the strengths and weaknesses of the opposition. And I make a good assessment of my client's case. And that is why, in fact, many of my cases often don't. I do a lot of legal opinions. I'm not in court every day. So I use those skills to avoid litigation in court. But I've been come back to your question, Commissioner Chepe. We had an engagement a few years ago, and I think the two of us, we very constructively settled the matter that we really didn't want to go further than the two of us. And I think those attributes help when you're a judge. I can demonstrate an example for you. And it's just one example of many. When we do third division, we do motion court, and normally at the end of third division we have divorces, and then we have Rule 43 interim orders pending final divorce orders. So my attitude is to call the parties in the morning, especially I'm just referring now to the Rule 43 matters. I say, you're going to come up at the end of the row, don't come to court, use the time to try to come to an agreement. Either narrow the issues or agree. Often they come back to court with the order. And I tell them the reason why. I've done it in court, in fact, in front of everybody else, where I told parties that this is not the matter that I want to hear argument on. It's an interim arrangement that you want the court to order on. I don't see why the parties cannot agree with it. Often there are children involved. Arguing matters in court and enforcing orders has a negative effect on the parties and especially on the children. So I try them to come to an agreement. And I use those mediation skills all the time.
Thank you, Mr. Hockey. Thank you, CJ.
Follow up, CJ.
Thank you very much, ma'am. Yes, go ahead, Honorable Minister.
What is your view to the criticism that the overuse of arbitration and commercial disputes in South Africa denies the courts an opportunity to develop jurisprudence on complex commercial matters, while we do acknowledge that arbitration does help to expeditiously deal with matters and so forth. But to that aspect of developing jurisprudence, what is your view on that?
Honorable Minister, I think firstly, I don't have any strong views which system is best. I have confidence in the courts. I think our courts are amazing. I have confidence, but there are instances where parties would have agreed in corporate agreements that if there are certain disputes that arise between them, they must go to arbitration. I still think there are very complex matters that come to court, and as a judge, we must deal with it. I don't have strong views. I think the nature of our system and the wonder of our system is that we give leeway. There's freedom, and parties must decide. I personally never pushed arbitration. I think the courts are very competent to deal with complex issues. But I see where you're getting at. I think there are people, let's be honest about it, there are practitioners that mistrust the court system. I don't agree with that. And they tell their clients, let's arbitrate, because we don't know what we're going to get in court. There are those people. I don't ascribe to those beliefs.
Yeah, that is another aspect, but remember the other aspect is that the arbitration is confidential, and even the arbitration award itself is confidential. So it also denies any other party some kind of precedence or that could help, even if it's an arbitration matter, but you can't get any form of precedence from that.
Yes.
It is only known between the parties.
Agreed. That's unfortunate. Obviously, there are sometimes justifiably instances where people don't want to hang out with this dirty washing in public. There are sometimes confidential commercial issues that are dealt with that people don't want competitors to get to know of. So for those reasons, the confidentiality aspect of it is understood. But I fully agree with it that the benefit that we can get from those complex, sometimes very complex arbitrations are not there for the general public. But I do think in the same vein, Honourable Minister, that our courts are dealing on a daily basis with extremely complex commercial corporate matters.
No, okay. No, that's fine. Thank you. Thank you, CJ.
Thank you, Minister. Professor.
Thank you, CJ. Good afternoon, sir. We met in the lift yesterday evening.
We did indeed, Professor Sleeman.
Would you mind sharing your judicial philosophy with me?
My judicial philosophy, Prof, is that we live in a constitutional democracy. So when a judicial officer exercises his or her judicial functions, it must be done in terms of the prescripts of the Constitution, and the Constitution informs and facilitates the rule of law. That in a nutshell is my judicial philosophy. I think with that goes questions of substantive and procedural questions. I think procedural aspects are also important. But substantively, when a power is exercised by a public functionary, It must, of course, be exercised in fairness and not arbitrarily. It also requires that there must be a set of rules, laws that are clear and fair. And on the procedural aspects, of course, exercise of any public power must be done with fairness, which includes your outre partem rule, and under our democratic democracy, public participation sometimes, often, if people are affected by whatever powers are exercised. In a nutshell, Professor, that is my approach, my judicial philosophy. I hope that is that answers the
Thank you for that. A next question that I want to pose to you is based on something also that the GCB says in their argument, in their document. They say we have to weigh up objectively the quality and diversity of your judgments against the other candidates. What, in your perception, is the quality of a good judgment?
The quality of a good judgment, firstly, I believe in part of quality, not everybody may think this way, but part of quality is to be clear. I'm a big proponent of clear, simple language. That is part of it, but otherwise, judgment must consider all the issues. It must analyze the facts. It must apply the law to those facts, and it must be convincing. It must be convincing. It must be astute. Every judgment should be almost like a thesis. I believe it must be scholarly. I know that is a word that has been used, but I think I give a lot of time and effort in my judgments, and I think it is the duty of every judge to, if you want to dispense justice, you must write a good quality judgment. Different judgments structure the judgments differently. I've got a particular way, but yes, I don't know if that answered everything that you wanted to hear, but we can talk about it for a long time.
Thank you, sir. Thank you, Chief Justice.
Thank you, Prof. Honorable Brayton.
Thank you very much, Chief Justice. Good afternoon, sir.
Good afternoon, Honorable Brayton.
I'm sorry, I have poor connectivity, so I'm hoping to preserve the sound by not switching on a picture. You'll agree with me that part of the duties of this body, this JSC, is to protect the independence, impartiality, and effectiveness of the courts.
Yes.
Should a situation arise where a judge who has been found guilty of gross misconduct continues to perform the duties of a judge, notwithstanding such a finding, would this, in your view, not of necessity weaken the legitimacy of the bench, thus eroding its independence and effectiveness?
Honorable Breitenbach, that question is obviously asked in a particular context. I'm going to ask that I please don't be drawn into the debate about the Judge President of the Western Cape. I say that for various reasons. I can motivate why.
Please do.
I get along very well with the Judge President. I'm very pleased with the opportunities that he's given me. He's given me work that's complex. I get along with him, and I do get along with every single judge. You know, we sit with judges all the time as colleagues in appeals, etc. And I had absolutely no problem with any of them. Neither, I believe, they have with me. I think all of them, without exception, support. I can't say because there are some that didn't indicate, but many of them have in fact indicated that wish me luck. And I personally would like to retain those relationships. with everybody. I've got good friends there, and I tell them, in fact, when I started last year, when I started my acting stint, I told them that I'm not going to get drawn into this debate. People put you in a camp so easily. And I think it's very unfair, very unfair. Everybody agrees that there must be collegiality. Everybody across the board. There must be collegiality at the Cape Ends. And once you get put in camps, it makes it very difficult. You know, there are perceptions which are sometimes unfair. So I ask you, please don't involve me in that debate.
Thank you very much, sir. Unwittingly, you have in fact answered my question. Thank you. Thank you. I'm done, Chief Justice.
President, thank you very much. Over.
Thank you, Chief Justice. Good afternoon, Mr. Hockey.
Hello, President.
Molo Shongololo tells us that you're a passionate advocate of children's rights and have extensive involvement in their operations. Thank you. I just want to thank you for that. We need many more men in this country who will protect our children. Now, first, a quick follow-up to the minister's lamentation about the possibly adverse effect of arbitration to our jurisprudence. Would you not agree with me that the court will always have a place in dispute resolution, because things do go wrong in the world of arbitration, and when that happens, where do the parties go? They come running to the courts, and we see those kind of cases every now and then in our courts.
Absolutely, no, I agree with you fully, President. Fully, I agree with that. The courts have a very, very important role to play. As indicated, sometimes people resort to arbitrations, but they end up in court. So I have full confidence in the courts, its capabilities, and its role.
Yeah. Just one question. According to your declaration in your questionnaire, and the GCB raises this as well, you have negligible experience in criminal law. Could this deficiency, if I may call it that, compromise your ability to preside in this big and important component of High Court work?
President, I disagree. I've got experience. As I said earlier on, I cut my teeth in criminal law. I ran the criminal law department in my previous firm for a while. It was many years ago, but it's like riding a bicycle. Once you can ride it and you put it aside, and 20 years later you get onto it, you ride again. I'm comfortable in criminal law. I've done quite a number of matters, applications that involves criminal law, appeals, applications. In fact, if you look at the cases that I've submitted with my application, there are criminal law involved there. There's a matter there that I think is very important for criminal law jurisprudence concerning the Firearms Control Act. We analyzed the act, and it was basically an application, a Ray Vindicatio application, where somebody that transgressed the rules and regulations in the act, Firearms Control Act, and they wanted the police confiscated. They wanted the firearms back. I ruled against him, of course, but that's part of criminal law jurisprudence. I've got a. I'm not a criminal lawyer. I haven't done criminal law for practice. In fact, I did do a criminal law case about 2-3 years ago, where I had the opportunity to also use my mediation skills with the listeriosis matter that happenings. I think it was about 3 years ago. One of my clients faced charges, and I engaged with the prosecuting authorities and had good discussions, and it culminated in a Section 105 capital A plea and sentence agreement. So I've got the capabilities. I can do it. I'm comfortable with criminal law. And as I said earlier on, black lawyers from my era are expected to know only criminal law, MVAs, matrimonial law, the odd civil law matter in the magistrate's court. I've broken those shackles, and I armed myself to do other work, and I bring that as a black lawyer. There are many other black lawyers that's got very good and vast criminal law experience that can contribute that to the bench. I can make another contribution, but I must say, criminal law is a very, very important part of the High Court. It's a very, very important function of the High Court, because that is where serious cases are heard, and that is where we lay down precedents for the lower courts. And I can deal with it. I'm very comfortable with criminal law.
But the GCB complains that you sat only in one criminal trial.
Yes.
But they do say that it was a big one. How did things go there? Were you able to cope? Did things go comfortably for you?
Unqualifiedly, yes. Yes, I coped with it. I can deal with criminal trials. I've done them. I've done many of them. I've as a litigator, as a lawyer, I've in my early years of my practice, I've at one stage I was destined to become a very respected criminal lawyer. The magistrates all got to know me, and but it is not the path that I wanted to go down. I wanted to do other things.
Thank you very much, Mr. Hockey. I'm satisfied. Thank you, CJ.
Thank you, President. Thank you, President. You're excused, Mr. Hockey.
Thank you, Chief Justice. Thank you, Commissioners.
Thank you, Mr. Hockey.